What's up, friends? Lincoln Lawyer here. I am here on a very hot freaking day in Miami with Pegasus. As you can see, this is the Gulf Stream. So today we're going to discuss private placement memoranda. All right, it's going to be a fun topic. So, private placements. What are private placements? Private placements are not public placements. All right, a public placement is where you go to an online broker and you buy it online. That's a public placement. All right, it's publicly traded companies. Private placements is a totally separate channel of investment. Private placement is not public. So this generally goes through Reg D, 506B and C. B is not used so much because B requires a pre-existing relationship with an investor. And basically it's very hard to find people like that. Also, it does allow 35 non-accredited investors, but the definition is unclear. It's very difficult to ascertain. They have to be sophisticated, and it's really basically subjective, and they can still sue you. It doesn't matter. So we're not really going to talk about 506B. All right, we're going to talk about pretty much 506C. 506C, Reg D, allows public advertisement. That's the best one, where you can advertise anywhere to the general public. All right, so pretty much, is a private placement memorandum required to be provided to an investor? It's just a big old document that outlines the nature of the investment. The answer is no. No, it does not. All right, there's nothing in the law that requires a PPM, private placement memorandum, to be provided to an investor. But should you provide one? Yeah, you should. You seriously should. You gotta do it. You just gotta do it, because if you don't, you're still subject to all the anti-fraud laws, full disclosure, and omission type stuff. All right, so if you fail to disclose, if you misrepresent anything, and the investor later comes back, says, yeah, you lied to me, you didn't disclose this, did that, I needed to know that, blah, 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 nothing's written down, I don't have anything, we talked on the phone, I gave you my money, blah, 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 well, you're gonna lose. You're just gonna freaking lose, all right? It's very simple. So you are subject to all the disclosure requirements. You gotta disclose everything. You can't omit anything. Anything material needs to be disclosed, period. If, as an investor, you would want to have that information before you make an investment, that is material. You need to disclose it, period. So that's why you need a PPM. PPM is a complex document. It needs to be drafted by a lawyer. All right. Generally, PPMs will start out with boilerplate. What's in that boilerplate? Generally, that's going to be confidentiality stuff. The offeror, the issuer, doesn't want this stuff getting out. This is confidential stuff. So they're going to make sure that it says it's confidential. It's going to be tracked. Each offering memorandum, each PPM is going to be tracked to a specific investor. So it's going to be confidential. It's going to state it right on the top. All right? It's going to tell you that the securities that are being offered are unregistered with the SEC. They're not valid for public offerings. All right? So changes in the offering structure may occur after the offering is closed. All right, it's very important. So the company structure, any interests being offered, being sold, they may change after you buy your interests. So they may become more favorable or less favorable. It depends. It depends how it goes. So you never know. So it'll also say securities may not be sold without SEC registration. Very simple. All right. So you got to register securities with SEC to sell them on the public market. You can't just sell it to anybody. You can't just buy this stuff and then sell it to your uncle or whatever. They got to be registered to be sold on the public market. That's it. All right. So also, what it will say is the investment that the investor may get into will incur risks that the investor must bear. All right. Significant risks. These risks are going to be described in greater detail inside the PPM itself. So it'll also tell you that the investor may meet with the issuer and ask any questions and obtain any documents that it may want. This is a legal requirement. So the issuer must permit full access to due diligence documents and to ask any questions that the investor may have. Next is it'll have a disclaimer about forward-looking statements. All right, forward-looking statements are speculative. It'll probably be in big bold letters. All right, it's going to be projections in the PPM, how the investment is going to do, how much money it's going to make, yada yada. Plans, investment strategy, all that shit is called forward-looking statements. All that shit is speculative. That's not necessarily how it's going to happen. Period. So you need to understand that. So also it'll have geographically required warnings by state. Each state has its own set of warnings that are required to be listed, and there'll be like 5 pages of various warnings for each state, each country, all kinds of shit. So it's not really that important. I mean, you need to understand that basically they're going to tell you that you can lose everything, your entire investment, and that's pretty much it, okay? So, investor needs to understand that they need to accept the fact that the total loss is very possible. Total loss of principal, extremely possible in any PPM. Furthermore, there may be a total inability to withdraw their principal for a prolonged period, if ever. All right, that principal may get stuck in that fund if, for whatever reason, the fund is at a loss, whatever, or it doesn't have the capital to give you. There's many reasons. I've been involved with crypto funds where they make an investment in a crypto offering and that crypto takes a shit. So that's it. They can't sell it. You can't get your money. That could apply to any fund. All right. If they can't liquidate their assets, their investment, and give you your principal back, then you're stuck. Period. You need to understand that. So the next part will likely be an offering summary. It'll have definitions. These are extremely important because some funds like to sneak in very sneaky little definitions that will really allow them to do some naughty stuff with your money. All right, so really got to pay attention to the definitions. So it's generally going to describe the offering, the investment strategy, the management fees. More or less, generally, they're going to be 220. All right, so 2% management fees annually, 20% on profits. That's pretty standard. All right, it varies now because funds have been taking a dump for a number of years with various economic swings. So it may be more, maybe less. It really depends on the fund. Also, the subscription process is going to be described, the duration of the investment, minimum investment amount, how distributions will be made, the transferal restrictions on the interest that an investor will be buying, redemption rights, tax issues, risk factors, voting rights, and disclaimers. There's going to be many of those. So this is all part of that thing where material disclosures are necessary, and the PPM is going to be very thorough. I mean, regardless if it's really relevant or not to the actual investment, they're going to make all kinds of disclosures. It doesn't even matter, you know, if they're ever even foreseeably likely to occur. Okay. So next part is going to go into greater detail about how the funds will be used, the investment funds, and who the eligible investors are. Company structure, usually it's going to be either 2 LLCs or an LLP structure where LLP, limited liability partnership, is going to be is going to have a general partner as an LLC is going to be the management company, and the limited partners are going to be the investors. Or it's going to be 2 LLCs, which I prefer personally, just for simplicity sakes, and that's where investors are going to be members of one LLC, and that LLC's funds are going to be managed by another LLC, and that's going to be the management company. It's pretty much the same thing, but generally LLCs are kind of becoming more popular now over the LLP structure. But it doesn't matter. It's still going to be partnership taxation, so you're still going to get the 1065. All right. So let's see. The subscription process, pretty simple. You're going to have to fill out the subscription documents. It's pretty basic. Disclose all your stuff, everything about your finances. All right. And you're going to have the accredited investor verification letter. So that's generally the investment structure. It may be a special purpose vehicle that acquires other companies. You really just need to go through that PPM and understand how they're going to be making their investments. Extremely important. But tax-wise, it's pretty much going to be K1s to limited partners, and shareholders will get their 1099 divs. So that's pretty standard. It doesn't really make much difference. So generally, it's also going to state that the fund manager is going to control all 100% of the investment activity. So the investor is going to have zero voting rights, no ability to vote, no control over the investments. Just make sure you understand that. A very important part of a PPM, it will likely have risk disclosures. All right, it's going to describe loss of principal, potential loss of principal. So it's going to state there's no guarantee of profit. All right. So, and then they're going to state that you may not have any right or possibility to get any documents on the investments. All right, whatever investments are made after your money is in the fund, you may not have any rights to obtain any of the financial statements, any of the financial activities, any details on the actual investments after your money is in there. Before, yes. After, not so much. Be aware. Additionally, all right, the disclosure, the PPM may state that investment activity may be delegated to a different fund. All right, if it's a fund of funds that invests in other funds, they have no control over investment activity. That the fund you invest in invests in other funds. Then the investee, the final fund that gets the funds, will have control. The fund that you're in doesn't have any control. You need to understand that, how that works. All right. So there's going to be some management terms. I mean, that's important. So if it's real estate, then it's going to be a management company. Basically, what you need to understand is that the PPM will tell you that you have no control. All right. I discussed this in my last video with Grant Cardone. When you put your money into a fund, you lose control. It's totally passive investment. You need to understand that. So they can do whatever they want with their funds, with your funds, and they take a management fee. So then a PPM will probably have a conflict of interest statement. Generally speaking, it's very common for funds to disclaim conflicts of interest. That means they can engage in self-interested transactions. All right, that means they can have an interest in the final investment. So the fund can be investing in an investment that one of the parties, the principals in the management team, the group, has an interest in. All right, and they may be making money on the money that is invested by the fund that you put your money into. You need to understand that. So they're disclaiming conflicts of interest. That is a conflict of interest. All right, if they're making money, if the manager is making money, anyone on the management group is making money off of your investment, that's a conflict of interest, and they can disclaim that. It's perfectly legal. You need to understand that. So it's pretty serious. All right. That's a red flag for me. Generally, I don't really go for that kind of thing with clients. So, also, the PPM may state additional financing rounds may be necessary. You may be asked to put in more money. Bam! You get a capital call. We're running out of money. Put in your money or you lose all your shit. That's it. Or your interest gets diluted. That shit happens. You need to understand that. So that's also a red flag. I'm not cool with that, generally speaking. I don't like doing that, all right? So make sure you understand that, all right? So additional capital calls. All right, so litigation risks. Litigation risks always present with any investment. That's pretty standard, not a big deal. Ability to withdraw funds and prohibitions on withdrawal, that's pretty standard. I mean, you'll be locked up. You'll be locked up for quite a while, all right, until the fund has sufficient, funds to liquidate and give you back your principal. So that's pretty much the nature of the beast of equity funds, private venture capital, equity, private equity, that kind of thing. Your funds are going to be locked up for a significant period of time, years, 5 years, maybe 10 years. Real estate funds, same thing. Grant Cardone's fund, you're going to be locked up. I mean, up to 10 years, maybe more. I mean, they might not even give you a right to withdraw your money. Potentially, that's possible, definitely possible. You might only have a right to get dividends for the remainder of the fund's life. You need to understand that, all right? Finally, fiduciary obligations. This is pretty important. I'm not really cool with any disclaimer of fiduciary obligations, all right? They need to have fiduciary obligations, the fund manager. They need to put your interests above theirs. So just like the conflict of interest disclaimers, I'm not really cool with that. The fiduciary obligations disclaimers are perfectly legal. They can do that. It's very common, but I'm not cool with it. All right, so they need to have some kind of fiduciary obligations. They need to put investor funds in front of their own interest. Just saying it. I mean, that's my thing about funds. If somebody wants to invest in a fund where they have no fiduciary obligations to their investors, that's perfectly fine. That is your choice. But you need to be aware of that. All right, to me, it's a red flag. So potentially they could make investments that make them money and lose your money. So you need to know that. All right. So that's pretty much a PPM. So it's a very detailed, significant document. There's about pretty much three large stacks of files that you'll generally get with any kind of fund situation. You will get the PPM, the subscription agreement, all right, which actually you fill out. It's a form. You provide your financial amount of investment, and you verify your accredited investor status. And you'll pretty much get an operating agreement or some kind of limited liability partnership agreement, which describes how the company where you're getting an interest in will be run. So that's pretty much the stack. There may be some other documents, but you know, it pretty much depends on the fund. So pretty much that's what you should be aware of. That's about all I have to say on the PPMs. These are very complicated documents. Don't try to review this stuff on your own. If you don't hire an expert to review this stuff, then the resulting loss of principal or whatever issues, you can't withdraw your principal forever, whatever. Well, that's your fault, you know, don't blame the fund, okay? So they probably disclosed it, all right? They know what they're doing. They have lawyers drafting these documents, so you should have a lawyer reviewing these documents. It's pretty much common sense, okay? I can't even like emphasize it anymore. If you don't get a lawyer to review these documents, you know, you deserve what you get. Very simple. Thank you for watching. I'm gonna go get some freaking water. Be cool. Take care.